This wasn't just a single stab wound. He stabbed her several times to the point where her head was nearly decapitated. It was gruesome. So obviously, she put up a fight. Really, she really wanted to attack her attacker, and in doing so, there was some blood splatter, like you stated, that was left in that trail. And he really thought that he took this death to his grave. But because of the advancement of science, technology, and of course DNA, it followed him to his grave. So even in his death, he cannot rest in peace because with the advancement of technology, which I'm grateful for, they were able to link the DNA, even though he thought he covered his fingerprints. Of course, DNA can be attached to you through blood splatter. In this case, it did. So, yeah, this was definitely a lazy, sloppy, crime scene, but he left a lot of clues that, of course, all roads led right back to him.
Richard John Davis. Not much is known about Richard John Davis. We do know that he lived with a roommate. We do know that he did not have any history of violent crimes. We know that he was a drinker, and we know that he had a history of driving drunk. We also know that he did die from alcoholism in 1997 when he was only 54 years old. Here's what we do know. We do know that this neighbor would soon commit a heinous murder of convenience that would remain unsolved for years. The sin, sloth. Sloth is defined as a lack of motivation and a general disinclination to work. It can also refer to a lack of concern for oneself and for others. A world of despair, boredom, restlessness, and spiritual indifference culminating in one giant shrug. This is the why behind the crime, the motive. I'm Ashley Willcott. I'm a TV anchor, a judge, a trial lawyer, and I would say that almost every case I've ever covered intersects with one of the 7 deadly sins: pride, greed, wrath, envy, lust, gluttony, and sloth. The opposite of the 7 heavenly virtues. Temptations that, if taken too far, turn deadly. This week, we break down the case of Richard John Davis and how the deadly sin of sloth turned this neighbor into a lazy ass murder. A little later, I'm joined by Kasia Earley in our breakdown segment, where we go deep into the how and the why of one of the longest cold cases of the 20th century. Let's get into it. This is the Deadly 7. We may not know a lot about Richard John Davis, but we do know a lot about Nancy Marie Bennallack. In 1970, Nancy Marie Bennallack was a 28-year-old vibrant young lady, a court reporter, and she was engaged to get married just that year. On a Sunday evening, October 25th of 1970, Nancy Bennallack was out with her fiancé. They'd been out for the evening, and around 11 p.m., they returned to her Sacramento, California apartment as she had to go to work the next Monday morning. After she got home, her fiancé left, and Nancy got ready for bed. The next morning, on Monday, October 26th of 1970, Nancy didn't show up at work, which was unusual. Her coworkers got concerned, and so one of her coworkers asked their son to go to her apartment and just make sure she was okay. The son didn't have any luck getting in touch with Nancy, so he went to the apartment complex manager and explained the situation and asked could they check on Nancy. They used a master key, and the coworker's son and the manager got into Nancy's apartment. Once they got in, they saw the worst explanation you can imagine for Nancy missing work. Nancy's body was in her bedroom. She had been stabbed over 30 times. The repeated stabbing was so brutal, it nearly resulted in her decapitation. Clearly, she had been murdered. The police put together that her fiancé left Nancy's apartment where she lived alone around 11:30 p.m. on the night of Sunday, October 25th. And her body was found early that next morning. There were no signs of forcible entry into the home. Now, Nancy did often leave her balcony door ajar so that her cat could come and go. This door was determined as the most likely entry point for the killer. Unfortunately, neither the door nor any other surface in the apartment had any fingerprint evidence, indicating the killer knew to cover their fingers. There were many defensive wounds on Nancy's body, showing that she had tried to fight off the attack. The investigation produced 500 potential suspects who were interviewed in that month following her murder. Each person interviewed was eliminated or, at the very least, had an alibi for the early morning of October 26th. Her neighbor, Richard John Davis, was actually interviewed during that initial investigation, and his roommate vouched for his whereabouts in the early morning of October 26th of 1970. There was evidence at the scene. There was a blood trail that went from her bedroom to the parking lot. But detectives at the time were no closer to identifying a suspect. Remember, DNA testing would not be used for forensic purposes until the mid-1980s, and this was still in 1970. Luckily, though, the blood evidence was collected, but the case of Nancy Bennallack would soon come to a standstill. It was not until more than 50 years later, one of the longest cold cases in Sacramento, California. It was in August of 2022 that Nancy's case was solved by investigators at the Sacramento County Sheriff's Office and the Sacramento County District Attorney's Office. Why? Because they used DNA genealogy techniques to identify Richard John Davis, her neighbor, as the killer. What happened is, in 2004, investigators reopened the case and obtained a DNA profile left by the killer at the crime scene. That was from that blood trail. They then entered that profile into the FBI's combined DNA index system, known to most of us as CODIS. Now, CODIS is a national database of DNA to help search for potential leads, but CODIS only contains those whose fingerprints have been provided. So this generated no leads in this case. And the lack of leads in 2004 left her family, who was very close to her and advocated for her along with her fiancé, it really left them in shock and anguish because the killer still remained unidentified, and justice to them, they said, seemed elusive. Then in 2021, the Sacramento County District Attorney's Office was awarded a grant, and this was called the Prosecuting Cold Cases Using DNA Grant. It enabled them to use technology and funding to actually compare the DNA in the blood at the crime scene to forensic genetic genealogy, FGG. And this is genetic genealogy that you and I are familiar with because it's a system that you might choose to send in your sample to find out about your family tree. There are a number of different companies that do that now. So it searches the DNA against the public family tree or ancestry database. In 2019, the DNA profile found at the home of Nancy was uploaded into one of these publicly accessible genealogical databases, and a family tree was built. That family tree took 2 years to build. After they built the family tree, the potential attacker was identified again as Richard John Davis, who did reside in the same apartment complex, who had been interviewed and gave an alibi. His roommate said he'd been home. But the investigators were able to identify a family member of him. and they cooperated. The family member did. They provided a DNA sample, which then confirmed Davis as the suspect. On the night of October 26th of 1970, police believe that Davis put tape, like is found in most homes, tape you wrap a present with, Scotch tape, on his fingertips to avoid leaving fingerprints, and then climbed up the balcony and entered her apartment. He was apparently cut badly during the attack, perhaps while Bennallack fought for her life, which is why he left the trail of blood that eventually led to his being caught as the murderer. His laziness and sloppy work identified him as Nancy's killer after more than 50 years as a cold case. Of course, it is my absolute honor to welcome and introduce Kasia Earley to you, a beautiful criminal defense attorney. So good at what you do. So grateful you've joined us today. I want to just make a few comments about this particular murderer. He died before he was ever tried for this crime, but the DNA evidence does say that, yes, he's the one that did it. And all I could think, Casey, when I was reviewing this case, preparing, doing all my research, is what a lazy ass murder. I tied it to the seven deadly sins of sloth because he simply sneaks into another apartment where he lives through a balcony that's open for a cat coming in and out and kills this vibrant 28-year-old with her whole life in front of her, uses a common item found in every house, tape, to put on his fingertips so he doesn't leave fingerprints, leaves a trail of blood from the apartment all the way to the parking lot, couldn't even take the time to find a victim, for lack of a better description, other than someone who randomly lived in the apartment complex. And this definition really stood out to me of sloth: a world of despair, boredom, restlessness, and spiritual indifference culminating in one giant shrug. And I felt like this murder was just a giant shrug to him in his laziness. So let me stop there and just have you weigh in initially on what you thought as you learned about this particular murder.
Yeah, there were so many things about this case that made it heinous, especially the way she died, right? So, as I was doing the research, I realized that this wasn't just a single stab wound. He stabbed her several times to the point where her head was nearly decapitated. It was gruesome. So, obviously, she put up a fight, really. She really wanted to attack her attacker. And in doing so, there was some blood splatter, like you stated, that was left in that trail, and he really thought that he took this death to his grave. But because of the advancement of science, technology, and of course DNA, it followed him to his grave. So even in his death, he cannot rest in peace because with the advancement of technology, which I'm grateful for, they were able to link the DNA, even though he thought he covered his fingerprints. Of course, DNA can be attached to you through blood splatter. In this case, it did. So yeah, this was definitely a lazy, sloppy, crime scene, but he left a lot of clues that, of course, all roads led right back to him.
Great point that he left so many clues. And I will say, in this particular case, as I was reading about it and the clues he left, I too thought, well, thank goodness, because they were able to catch him. I believe every cold case is solved. I know it can be 50 years, 100 years, but I truly believe in my heart that eventually they figure out what happened, even if it takes that many years. And she had a family that continued to advocate for her and wanting to find out what happened. And I think that makes a difference. But I want to talk about the DNA part because we both know you also do civil rights cases. And there's some due process rights I want to talk to you about because let's fast forward. And a number of different cases, specifically, especially in California, have been solved using the public databases that people send their DNA to. So I say, I want to find out about my family and my genealogy. So I'm going to submit my sample, have it tested, expecting they're just going to send back to me all the information that they've learned. And the question becomes, do I also have an expectation of privacy that is waived when I send my sample off so that law enforcement can then compare DNA to everyone's DNA that has freely, willingly sent in a sample, but perhaps expecting that that would be confidential, that nobody could access that. So, where do you fall with that, Kasia? The argument that due process means I have a right to have my DNA sample protected and not compare against those of potential criminals.
Judge Ashley, that's a great point. And as you were speaking, in my head, I was thinking there's no reasonable expectation of privacy when you're submitting your DNA to a third party. Because think about it, you're submitting your DNA to an unknown party. You don't know how many people are handling the DNA. You did not submit a waiver or any type of documentation stating that I do not waive uh, my DNA to be used by two people or anything like that. So there's no reasonable expectation of privacy in that point. And I do believe it's for the public good that law enforcement work hand in hand with these third party DNA companies because sometimes this is the only way that you can crack a case. It's similar to when you are considered a suspect in a crime and you throw out your trash. Well, there was no reasonable expectation of privacy there because you threw it out. You knew that a third party, which is a garbage collector, is going to collect the trash and they have free reign to collect DNA. In fact, this is how they solve cases. So I do not believe that there's a strong case, even if someone wanted to argue that it was only submitted, the DNA was only submitted for this exclusive use. It's still not a strong argument. I do believe that the public protection of the public is more important and serves a greater purpose than you wanting to have exclusive use to your DNA. So, in this case, this is how most cold cases are cracked through DNA or through going through the trash. So that is not a strong argument that will hold up in court.
And I do love your example of the trash because a current case, Brian Koberger, who is
Yes.
accused of killing 4 students, there was a whole argument or preliminary motion about they should not have been allowed to use the DNA sample of the father that was found on the pizza box in the trash can. And the judge said just what you said, which is you don't have an expectation of privacy. The Supreme Court's ruled on that. If it's in your
Yes.
trash, it's free game. Law enforcement can dig through it and use it. But let me take it a step further because there's been an argument made that when a person submits their DNA, that some public companies have a disclaimer that says you can expect that we are only using this to provide the results to you. But I don't think that company has the ability to really contractually say that because of what you just said, weighing it against the public interest. I think the company may be inadvertently learning now that they're misleading the public because they may not be able to commit to a disclaimer or a disclosure that says this information's private. What do you think about that piece?
I think this is why contract attorneys are so important because the laws are always changing and also the interests of the parties and the expectation. I mean, in this case, usually with these third party DNA companies, they don't expect that they're also going to be utilized to help solve crimes. Their main goal is to make money. And excuse me, and in that business of making money, they want to fulfill their obligation, which is tying your genealogy and making sure that they fulfill their requirement. But sometimes the laws change. And in this case, the public interest outweighs what they were initially legally contracted to do. So, contract lawyers are very important because they have to keep up with the times, they have to change these contracts. And oftentimes, most of these contracts, when you think about it, whether it's our cell phone contracts or if we're submitting DNA, these are contracts of adhesion because who really reads through all of that information or just clicks, especially if you're submitting online documents. We just, even as a lawyer, guilty, you just click because you're like, get out of here. So there's argument for if someone submits their DNA under, they can have an argument that, I submitted it solely for this, therefore my DNA should be excluded or that evidence should be excluded. But again, it's always the current status of case law, statute, and coupled with the public good.
And I want to give you a little bit of a statistic because the Sacramento, California Sheriff's Office, who in conjunction with the DA's office solved this crime, said that 11 cases of their jurisdiction with 17 murders 59 rape cases and 3 unidentified remains have been solved there using the new genetic testing, comparing it to the public samples. And it's the same that you made the Golden State Killer, Joseph D'Angelo.
Yes.
It's the same genealogy testing that solved that crime. So it's been very successful for them. But let's turn back to Richard John Davis. If he had still been alive when they used this genealogy testing and said his blood was at the crime scene, it matches him, he's the one who did it. As a criminal defense attorney, especially if you're trying a case that's been cold for more than 50 years, how do you first approach it in terms of how you defend a person that's been linked by one way, and that's the genealogy, the DNA? No other evidence links him to the crime.
Yeah, I just got out of a murder case where the only evidence that linked my client to this crime was DNA. And oftentimes you can't fight DNA, especially if there's a single contributor. That means only you were there, only you touched the item, you're the only source. And then on top of that, they do confirmatory testing where it confirms what they initially got the hit from. And in my case, the confirmatory testing was 700 billion times likely. And we don't even have that amount of people in this entire world. So when you're dealt with that much statistical information or scientific information that is completely against you because it's overwhelming, you don't fight it. You don't fight it because if you fight that, you're basically going to lose the jury. When I say don't fight it, I'm not saying don't uh, zealously advocate for your client. What I'm saying is if you're going to fight DNA that is that certain, um, you better have enough information or have an expert that's willing to fight the way it was tested. Maybe it was improperly handled, the evidence wasn't collected. But if your only source is, yeah, it's 700 billion times likely I'm the contributor, but that's not me, then that's an uphill battle. You're going to turn a jury off, guilty verdict. And in this case, I do believe he was a single contributor. Blood, unless it was mixed with other blood other than the victim, there's no way that he can wiggle out of that. And we always have this information in the beginning. So we know that it was his DNA and he was alive. Most likely you want to mitigate instead of taking it to trial because you'll have a better outcome as opposed to fighting something that's the inevitable.
And sometimes in cases like that, we do see the mitigation is they agree to plead guilty, but for instance, the death penalty might get taken off the table if it's a state with the death penalty. Or in the alternative, I think I've seen it where, believe it or not, it was a nolo plea, meaning they weren't admitting guilt, but they weren't contesting that the evidence would likely show that they'd done it. And they still had a very long sentence, but they were willing to agree to it because they weren't having to admit guilt. So I know there are lots of different ways to try to mitigate, to try to work out a plea agreement, but I think, Kasia, that I also see frequently if there's blood, and to your point, if it's can't be argued that it's not their blood. I feel like that sometimes is when defendants say, oh, it was self defense. My blood is there because she attacked me. Now, she had a lot of wounds that they say were because she was fighting off her attacker. But could there be a potential argument if he were still alive, if he were trying to defend himself, to say, yeah, I was defending myself. She started it. I mean, that's hard pressed because he probably came in through the balcony. But I think blood
Yes.
can sometimes lead to that argument of, oh, it was self defense.
In any other case, but just as you stated, it wouldn't work here because it wasn't like she knew him and she invited him over and maybe they were about to engage and then she stopped him and then there was a struggle. He went through the balcony. So even if he claims there was self-defense, it wouldn't have worked because of how he gained entry as opposed to being let in because she wanted him to come in. So that wouldn't work. And again, when you're preparing cases or when I prepare cases, I look at the totality of the circumstances. And I always tell my client, you can tell me your side, but I have to follow the evidence. And where the evidence goes is that's how I'm going to best prepare a legal defense for you. Because if you're telling me, I wasn't there, but there's evidence that shows that you are, I'm going to present that evidence to you. And if you continue to fight and resist, you are going to have a guilty verdict. So it's sometimes up to the attorney to have a real conversation with our clients. And again, I look at the evidence. I go where the evidence takes me. If the evidence tells me contrary to what your defense is, I tell my client it's weak and we have to restructure. In other words, tell me the truth. And this is the great thing about being a lawyer. We want our clients to be completely honest with us because if not, we're going to be blindsided during trial, ill prepared during trial, and then, of course, it's our client's future.
Yeah, it's really hard to zealously advocate if you go to trial and get caught with your pants down, right? Like, that's my analogy because you're just kinda stuck then saying, "I don't really know how to best prepare to
Yeah.
to refute this because you never told me about this." And it's why I really value you, Casey, as a criminal defense attorney because you're honest with your client, you're advising them, you're counseling them. That's what an attorney's supposed to do as they represent a client. In this particular case and in general, tell me what you think about defendants being lazy. Do you have any examples of cases where sloth is the motive that they don't want to deal with something or they don't care about themselves or someone else to even do anything about it?
Unfortunately, most of the cases that I take to trial, there's at least a one bit of evidence that really blows the case up. And although you may think it's small, it really attacks the credibility of my client. I mean, I've tried several cases from misdemeanor to murder, and usually it's the murder cases where that one piece of evidence I just can't refute, and we have to try the case. There's no deal on the table, and if there is a deal, you might as well try it and hope for mistrial. Or one person, one juror, at least saying, you know what, there is reasonable doubt. The last case I did, there was DNA left on not a bullet, but on a gun mounted light. And the way the state presented the evidence was the gun mounted light matched the 9 millimeter that was found near the gun mounted light. And of course, with my zealous advocacy, I said, well, gun mounts don't kill, bullets do. And how do we know that that was on that particular gun? So sometimes you have to face the bad facts, but you can also provide an alternative explanation as to how that got there. But oftentimes we see it all the time. I had another client who allegedly committed a crime, but he had an ankle monitor on that placed him in the position right at the scene of the crime. And,
I thought you were gonna say the opposite, Casey. I thought you were gonna say, "And it placed him, that was his alibi," but no, you're saying it put him
no.
at the scene.
So you have to explain, and sometimes you think, "What were you thinking?" This is not like it's cell phone, tower where it gives a radius, approximate location. This is a GPS ankle monitor, and you're at the location of this alleged crime. But again, you have to give an alternative theory, because there's no deal on the table, and of course, you can't just say coincidence. We have to explain. So there's I've had several examples of how my clients allegedly placed themselves in a position and the evidence also places them there. You just really have to fight, attack the evidence, and hope for a great outcome.
And you're right, bad facts, both sides have to pay attention to because we teach in trial skills that you have to present the bad fact. You want to take the sting away, whether you're the state or the defense. It's how you present it, and you want to kind of bury it in the middle. So you don't make a big
There
deal
you
of
go.
it. Primacy, recency, you don't want your bad facts there, but you have to deal with them when you're in court, regardless of what side you are on. Lastly, in this particular case, how do you feel about justice for the family? We know he died. We know they learned after his death exactly who killed their daughter. Does that give any, I hate to use the word closure because nobody gets closure after someone in their family they're close to is murdered, but how does it affect justice for the family?
I think that they welcome it because oftentimes, and I agree with you. I don't like to say the family, even as a criminal defense attorney, there's never closure, but at least there's some form of relief in knowing that the crime was solved. And as a believer, you also believe that even though he died without justice here on earth, I do believe that there is justice, after death. And if he did not ask for forgiveness of his sins, and obviously he didn't because, he took it to his grave, so he thought. And again, as I stated, it followed him. So I know that the family is relieved that maybe who they suspected all along was finally confirmed thanks to science and DNA. And I know that this is one step to healing because it's an ongoing process. It comes in spurts, just like grieving the loss of a loved one. But I'm glad that they welcome that this is finally has been confirmed.
Yeah, absolutely. Kasia Earley, I cannot thank you enough. Fantastic to have you, criminal defense attorney. And I just have to end and say Richard John Davis. He was caught as the killer of Nancy. A world of despair, boredom, restlessness, and spiritual indifference, culminating in one giant shrug. I think that defines this murder. Thank you, Kasia.
Thanks for having me.